SJC-11958, Administrator of the Estate of Herman T. Bayless Sr. v. TTS Trio Corporation, doing business as Kaizen Restaurant and others.
Good morning, Mr. Ober. Give us a moment. Okay, you may proceed.
Good morning, Your Honors. Scott Ober for the appellants, TTS Trio Corporation, and the individual appellants. The primary issue before the court today is whether a filing that is not sworn to oath and entirely based on information and belief meets the affidavit requirement of General Laws, Chapter 231, Section 60J. It is the appellant's position that under any definition of the word affidavit, that the filing in this case does not rise to the level of an affidavit that is proper and sufficient as required by Section 60J.
What do you suppose the legislature had in mind when the legislature said that you needed to do an affidavit in addition to the complaint? Does it have anything to do with what, and to do it within such a short period of time? What do you think the legislature was after there?
Well, the purpose behind the affidavit requirement is to weed out claims that...
So fairly early on to weed them out, right?
Correct.
So you're not going to necessarily have lots of information at the same time that you're filing your complaint. But maybe because complaints are just, notice pleading, it could be very bare bones, you don't have to say much, and maybe because that doesn't really give you enough to weed it out, that you need to have something more in the affidavit. But the question is, how much more do you really need?
Well, I think there's got to be something that, one, is sworn to under oath, first and
Who is going to
foremost.
swear to it at that point?
Whoever is submitting...
Suppose it's the dead person's, this is brought by an estate. Who's supposed to do that?
Well, in this instance...
Who would know firsthand what happened here?
Correct. Well, obviously, in the case that is presented here, we've got a case brought by an estate. So obviously, the decedent is unable to file that affidavit, but...
And presumably, the legislature had that in mind.
Correct. And the filing in this instance, though, does reference individuals who presumably have knowledge of what occurred at the restaurant on the night in question, or with respect to the accident. For instance,
Should there be multiple affidavits then?
that's certainly a possibility.
It says affidavit, though.
One affidavit.
Correct. It says one affidavit, so that at a minimum, a single affidavit is required of the plaintiff when they are filing this. And it is I'm sorry, Your Honor. It's certainly something more than just a pleading in this case. If the legislature decided that there's something more than a complaint or a simple pleading needs to be filed, they required an affidavit.
Well, could it be the affidavit of the medical examiner that examined the body of the deceased and found that the person died and had a particular blood alcohol content? Would that affidavit suffice?
That may, and I think it would depend on the circumstances. In this case, there is reference to medical records that
But the affidavit under oath need not be an affidavit attesting to facts as to what went on inside the bar.
I think the affidavit has to support a finding or support evidence that at the time of last service that the decedent in this case was apparently intoxicated. So that if that evidence from the medical examiner under oath suggested that based on that information that there was sufficient evidence to show apparent intoxication at the time of last service, yes, that affidavit
that
from
here?
the medical examiner could be appropriate.
Don't we have that here?
No, we don't. What we have here is an affidavit, not even an affidavit. It's a document that is not sworn to and that refers to medical records that relate to testing that was done at some point after the accident. What we don't know is when that testing was done and what the significance of those findings were.
It's not supposed to be the substitute for discovery.
No, but it does have to show that.
I mean, this is supposed to be at a very early stage in the litigation, pre-discovery.
It's filed with a complaint.
Correct.
Or within 90 days.
And in this case, we have a filing that was made more than 3 years after the accident happened. So in terms of a situation where the court has some concern about the plaintiff not having sufficient time to conduct an investigation.
That's not the same thing as discovery.
Correct.
A plaintiff's investigation is not the same thing as discovery of defendants.
Correct. But the filing in this case does reference individuals, and again, it's not clear from the filing whether counsel spoke to these people as witnesses.
All of which can be discovered by the defendant in discovery.
Excuse me, Your Honor, I didn't.
Any of these details that you say you would need to have are available to be had in the process of discovery. You don't need to have them set out in the affidavit when the purpose of the affidavit is to screen out frivolous claims.
Correct. But in terms of this initial step, it's the purpose of it is to show that there's sufficient evidence to raise a legitimate question of liability. Here, we can't do that based on what has been submitted. One, because it's not under oath, and
Says, I certify the above to be true upon information of, he certifies it, he's an attorney. That doesn't help?
No, Your Honor, and it doesn't, and because
Just said, I swear the above is true except to the extent it's based on information and belief, and then I swear that I believe it to be true. He could do that? Would that make it?
I think as an initial factor, one, yes, he would need to swear under oath that the information contained in the affidavit is true and accurate based on his knowledge, and to the extent not based on his personal knowledge, indicate where it is based on information and belief.
Okay.
Here, we don't even have that initial step, and the
Say that it's based upon information and belief. It said police report, witness statements, and medical toxicology report. It's very clear.
correct, none of which is attached to that affidavit. So, and again, the importance of the oath and the attachment of those records here, I think, is highlighted by. You can look at one particular factor is there's reference in that affidavit, I believe in paragraph.
But if he had filed an affidavit, if the attorney filed an affidavit saying that I swear under oath that I have filed this complaint based upon the following materials that I have received in the course of conducting a pre-litigation investigation, number 1, police report, number 2, autopsy report, number 3, da-da-da-da. I don't know anything about the facts of this case myself personally, but based on my investigation, here's what I reasonably believe this case will show. Is that sufficient?
If it's sworn under oath, I think that it would need to be one. If it's entirely based on information and belief, then I
not even information and belief. It's based upon the having received the following documents: police report, autopsy report, statement of certain witness.
I would say at a minimum those documents would need to be attached, because in this case there's reference to the police report, and one of the statements that's made in this filing by counsel is that the plaintiff purchased 12 drinks at the restaurant between a 7-hour period from 1:50 to 8:50. The reasonable inference from that statement is that the decedent consumed those 12 beverages during that 7-hour period. Well, we know that's not true because the police report, which has been cited to for that purpose, says in the very next sentence, but which is not contained in plaintiff's filing, is that 5 of those purchased beverages were given to other individuals and that there were only 7 drinks potentially consumed within that 7-hour period. So again, we talk about the purpose of this oath. It is not just a technicality. It has a legal significance.
You get the documents, and then you move for summary judgment because you don't think there's enough there. I mean, what's wrong with that?
Well, that is what we.
Well, yes, but you're complaining about this affidavit. I'm
Correct.
just saying, you get the affidavit, you get this, and let's say it says at the top, affidavit, or maybe it does, I don't know if it does. And it has the documents attached. You do your own discovery, you say this is not good enough, move for summary judgment under 56?
Well, in this case, the affidavit, the documents weren't attached to the filing.
Ask for them.
Correct. But in terms of the plaintiff's initial burden of establishing a sufficient basis for the claim, at a minimum, I think those, if the filing is going to be entirely based on information and belief, those documents, I believe, need to be attached. But here, we're relying on counsel's unsworn to statements, which in essence amount to what a pleading is. I mean, in every case, an attorney has an obligation when they're filing a pleading to.
But this one makes very clear that the attorney has actually, he's done more than just allege. He's gotten a bunch of information that he's telling you what he's gotten, right?
There is reference to unidentified witnesses that we don't know if he's spoken to them or whether this is second, third, fourth-hand passed down information to the attorney from other sources. So again, we're not in a position to assess it because, one, it's not sworn to, and second, it's not based on any personal knowledge. We can't tell from the filing in this case whether the information contained in that filing is based on his individual investigation done during that 3+ year period since the accident, or if this is just information that has been passed down to him through sources that we have no idea and are unable to tell from the filing.
Does it
At
make
this
any difference?
stage,
Oh, sorry.
I'll defer to you.
Make any difference to you that there was a change in an earlier version that used to provide that the affidavit state facts which constitute a prima facie case, whereas now it's just raised a legitimate question of liability?
Can you repeat that, Your Honor?
Do you think it should make a difference that the legislature, using the phrase raise a legitimate question of liability, use that in lieu of language that used to say, instead of that the affidavit state facts which constitute a prima facie case?
Yes, I think the legislature is saying that you've got to come forward with more than just allegations that would be sufficient to meet a motion to dismiss standard. We've got to see some evidence that would warrant this case moving forward. And again, the purpose
So
behind
you're
that is
saying
preventing frivolous cases from moving forward.
You're saying that the affidavit, you're entitled to know at this stage whether the allegations are true, or is it just that you're supposed to be able to figure out, well, if this is true, if they can prove all of this, then this is a sufficient case, because you don't get to do discovery at this stage of the proceeding. I think the purpose of the statute is just to weed out, as somebody else has said, and so it doesn't matter if it's true or not at this stage.
Well, I think there's some assessment in that about the truthfulness, because that is the purpose of an affidavit. Certainly, an affidavit is putting forth facts that should be true. And so the purpose behind the affidavit is obviously to assess whether there's evidence to raise a legitimate question of liability. So we're certainly not suggesting that the plaintiff has to prove and win his case upon the filing of the affidavit, but it is certainly something more than just alleging, making allegations that are sufficient to get past a motion to dismiss. And if that were the case, the affidavit would be unnecessary. We'd be dealing with what are the allegations in the complaint, and are those sufficient here to move past a motion to dismiss standard?
So why should we not simply interpret this essentially as a bill of particulars? I mean, going beyond the facial allegation in the complaint and requiring essentially a bill of particulars for these types of cases. Isn't that essentially what the legislature did?
I think it's the purpose behind it is obviously to require something more than just pleading very specific facts to get past a motion to dismiss, and it's requiring the plaintiffs to, under oath, put forth evidence that would satisfy the trial judge that the case is one that is not frivolous and that is one that would warrant moving forward with discovery on the issue. So again, it's certainly not, I'm not suggesting that the affidavit is is required to, or the plaintiffs are required through the affidavit to prove their full case through the affidavit, but they are required under oath to put forth at least sufficient evidence that would satisfy the trial judge that the case is one that is not frivolous and that is one that should move forward. And
Well, doesn't this do it?
no, it doesn't, Your Honor, because one, the filing here is not signed under oath, and so under any definition of that term, if a filing is not signed under oath, it cannot be an affidavit. And second, where it's entirely based on information and belief and completely devoid of any personal knowledge, it can't meet the definition of an affidavit.
All right, thank you.
Thank you.
Good morning, Honorable
Good morning,
Justices.
Mr. Wessel.
My name is Ernie Wessel, excuse me. My name is Ernie Wessel. I am the attorney for the estate of the Bayless in this action here. Basically, the gist of this is what is the purpose of the affidavit. Basically, as it's said here in the court, it's a screening tool to weed out frivolous cases.
But why didn't, usually just using the word affidavit usually does have something sworn under oath. Is there some reason you didn't do that?
The 23160J is basically does not indicate what an affidavit must be, but it does
Well, I
direct
understand
us.
that, but usually an affidavit, whatever it is, and I understand the argument that it's not a 56E affidavit, but just the word affidavit usually does mean sworn under oath, I
Well,
think.
Rule 11, 23160J indicates that unless otherwise specified, we're to follow the Mass Rules of Civil Procedure, and Rule 11 indicates that an affidavit can be sworn to by a person with knowledge on behalf of a party.
But you didn't swear, all I'm saying is
Well,
you didn't swear
you
to
can
it.
submit one on behalf of the party. And in that case, an affidavit, when I was reading it, this is a civil case with civil issues according to the Mass Rules of Civil Procedure. And when I interpreted that, 268 section, this concerns affidavits. And that's basically a criminal chapter, the way I read that, if swear in a civil proceeding, and it didn't make sense. I could supply an affidavit based upon my investigation. I had nobody with complete knowledge of any of the facts. I had the SEMLAC report, which is the accident reconstruction report, the police report that was mentioned, where they interviewed Kaizen, and they indicated there were 12 drinks, but they haven't provided, we had initial discovery. There was nothing showing how many drinks were bought. They did provide a security video of 7 hours and 20 minutes of serving drinks, and I counted 9 drinks, not 12. So what they reported to the police was not accurate, and if I read the bar right, the last 4 were what I believe to be water glasses full of Jack Daniels. His last 4 drinks at the bar before he walked out that door at 8:59, and he died at 9:04. The accident, the police report, SEMLAC report, the medical examiner's report. We use a medical examiner's report, DNA evidence, saliva, hair from 20 years ago, and we're prosecuting cold cases. And if beyond a reasonable doubt, we use a medical examiner's reports. So why wouldn't that be good enough in this case? I couldn't swear that, under oath that these facts were true because I don't know personally that these are true. I do know that I did an investigation, and based upon an investigation, in belief, I attest that they're true. I attested under Rule 11, not knowing which way to go with this because it didn't state so in the statute. So I followed through according to the statute that I had available to me. As far as direct evidence, this court has ruled in Croto that in Croto they wanted to weed out frivolous cases as far as the affidavit. In Tobin, blood alcohol could be used as evidence of negligence. In
The same language about sufficient to something about liability, that's the same language that's in the medical malpractice statute, right?
yes, but the legislature put an additional, you needed experts in there. They didn't
Right,
put
but
experts in
but
this.
nobody's swearing under oath, right?
Not to my knowledge. I don't do medical mal. Okay, that requires a larger bank account than I have just to put up the witnesses. This is a part-time job for me, Your Honor. I am a full-time state officer. But the gist of this is basically medical reports, where you routinely use these medical reports, we routinely use police reports and crash reconstruction. I don't see why this would not pass muster under Mass Rules of Civil Procedure, where the legislature did basically pull back the reins on what is required in an affidavit. I wish I had somebody else that could swear under oath, but I had nobody at the time. This took nearly 3 years to even serve because the administrator that it was appointed had to complete the deceased wife's estate. She had died. She was a state employee, worked at the Department of Corrections. She died as a result of injuries. She succumbed to complications down the road. That was being probated. We couldn't probate this case and have him appointed until that other case was done. And he wasn't named executive till the end of June.
What would fall below the line? What kind of affidavit would be insufficient for purposes of 60J?
Well, I do not believe that anybody's saying, what would fall below the line? I had no reconstruction report. I had no police report. Blood alcohol. I mean, femoral and vitreous humor. I mean, that's some of the most potent evidence we have. Just a couple of people saying, yeah, I know him. What would fall below the line would be somebody, and this is what concerns me with the way the statute's written, with the way they're trying to have it read, is if we have a business person away from home, finishes a deal, and goes out and celebrates. Nobody in there is going to know that person personally. Has one for the road, walks away. You know, he'd been sitting there drinking for 7 hours. Now that should be enough circumstantial evidence to get to the jury, should they have known, if he was drinking consistently for 7 hours. And they killed somebody. Mothers Against Drunk Driving did a banner effort to make people responsible for their own behavior. But they also have to have responsibility of this alcohol serving industry.
So what's the problem with you swearing that what's in the affidavit is a summary of your investigation, and the defendant has a point here. I mean, in general, if nobody's standing behind what's being offered under the statute, you know, they could have a little discomfort with that. But what's wrong with you swearing that I did this investigation, this is what I've come up with, and it meets the requirements of the statute? Why couldn't you have done that?
Basically, there are affidavits. When I looked at the affidavit, there was one on the 268, and there was an affidavit set forth in the rules. And the rules basically, you follow Rule 11, you got to certify. So I went along according to that because it says you're going to follow the rules of civil procedure.
And you basically say, I certify the information
Yes.
is true based on 1, 2, 3, 4, 5, 6, 1, 2, 3, 4. Report, police reports, toxicology report, witness statements. So you're saying certify is true, signed by a lawyer who's
Yes.
conducted the investigation, pointing to on what he's relied is sufficient.
And whether you have an affidavit or you're certifying, I have both civil action, and I could be brought up in front of the BBO.
I guess if you hadn't, and going back to the question, just thinking about it, if you didn't know that it was such a close period of time where his last known place of imbibing occurred, but he was gone for 40 minutes, who knew, off the radar, then he's found on the side of the road. So then you are engaging in, and no daughter speaking to him on the phone, or just, he was out drinking, but who knows where, what was the source, who was the last place. If you don't have that, you're suggesting, because you do have those pieces, and you come so close to time, amount,
Yes.
we know it's this place, we don't speculate, as many cases haven't come up in the past do. Well, you know, he was on a binge, he went to 10 places, who knows, it was the last one, we think it was this. So that's your claim, is that's all you can do, or anyone can do, unless you happen through discovery to find Andrea
And since this has gone, since you took the case to a sponsor, I have located that individual. They had no employee records to give me. They couldn't give me a last name. She's under a different name now.
Ms. Andrea?
Yes, she's under a different name now. She went to Florida, came back through Connecticut, and is now back in Massachusetts working in another bar. This is, that's the other part of me, state officer. But there weren't even indications of any alcohol in the car when it crashed. And that is almost always put inside a police report. That is an important thing. No cans of beer, no alcohol, no smell of alcohol within the car as if it broke. I had to report to the scene because I reported to the scene on behalf of the brother because he had cases in the back and I was trying to pick up any paper that blew out. Every window was destroyed out of his car, put on a flatbed. You can imagine there's not a lot of paper left between the accident scene and where it was brought. So based on those facts, this is why I brought it forward the way I did.
All right, thank you.
Awesome.